Okay, A'udhu billahi minash shaitanir rajim. Bismillahir Rahmanir Rahim. As you see, today we'll discuss about the right of options, Khiyarat, right? The discussion on Khiyarat, maybe we discussed before, but that one, when it comes as a occasionally, right? But today we discuss details of some types of option. Khiyarat, this is the plural, right? Many options. The singular is khiyarul shart, khiyarul majlis, khiyarul aib, khiyarul ru'ya, right? The right of option we discussed today. Basically, today we discuss the four: the khiyarul majlis, the option during meeting, right? Meeting means the majlisul aqad, contracting session, the meeting for bargaining and discussion. Option of condition, khiyarul shart. Option of viewing or inspection, we discussed before briefly, right? Option of inspection, khiyarul ru'ya. Then option of defect, khiyarul aib, right? Khiyarul aib. If any problem found, then we can apply this option. So basically, option means what? You have choice. You can choose whether you continue the contract or you cancel the contract. This is called option, right? You can make a choice to do or not to do. This is option. So in when we do buying and selling, in certain condition or in certain situation, we can apply some type of option. This is called khiyar. Option is a device to safeguard the contracting parties. Right. Option. Why option is legalized? Why it is lawful? When there is ijab and kabul, right? The contract is concluded because ijab and kabul is the pillar of the contract, right? We have learned before. So contract can be concluded through ijab and kabul. However, even though ijab and kabul is been done, but still, if you apply an option, you can apply and you can utilize it. Why? To safeguard your rights and your asset. Maybe the seller, from the seller side, maybe the seller is not sure about the price. He doesn't know much about the market price, market situation, and so on. Right? He must be deceived by other people. So in that case, if he says, okay, I want to sell, but you have to give me 3 days option or 1 day option or 1 hour to think, right? So through this time, he can consult with other people, he can think more, he can deliberate, so he can come up a good decision, right? And also from the buyer side also, maybe the buyer does not know the price well. Maybe the buyer needs to consult with his guardian or her guardian or with someone who is expert or for his lawyer, he has to wait. So considering all this situation, the option is made lawful in Islam to safeguard the contracting parties so that everybody can be safe side and can make a good decision, right? So that they can avoid the adverse selection, the adverse exchange or adverse contract. Preventing measure against error, defect in goods, want of knowledge concerning quality of things, lack of desired quality. So anything can be happen, right? Maybe I don't know much about the quality or about the characteristic of this item, so I have to talk to someone else, right? Maybe the information is not enough given. So for any reason, to protect our right and to prevent the harm from the harm, the option is legalized and made lawful. Okay. So always the option is in line with Maqasid Sharia. What is the Maqasid Sharia? The gist of Maqasid Sharia is to achieve the benefit and to remove the harm. In Arabic called Jalbul Maslaha and Dar'ul Mafsada. Either you get some benefit or you can prevent the harm from yourself. You can be safe side. That's why the option is legalized. So option is basically kind of exception from the general principle, right? To ensure maslaha. Because what is the general principle? The general principle is as long as ijab and qabul is done, the contract should be final and concluded, right? This is the norms. But what is the exception from the norms? The exception is we can apply khiyarat. Why? To ensure our maslaha, right? To make sure that we are not making any wrong decision. All right. So the Arabic word khiyarat is the plural of khiyar, which means option. Literally, a contractor has right to ratify the contract or to annul means to cancel within the period of option. So this is a definition that I said already. Option means uh, to have the right to choose whether continue or cancel, right? Whether you want to continue the contract or you want to cancel the contract. But there should be the specific period. So maximum for the khiyarul shart, for example, 3 days, right? So within these 3 days maximum, you have to make a decision. After 3 days, for example, no choice. The contract become final. There are many types of option. Even Hanafi scholar they allow 17 types of option, right? Khiyarul majlis, option for contracting session. Khiyarul shart, option of condition. Khiyar at-ta'yin, option of determination. To choose which one you buy or which one you sell. To choose among the subject matters. Khiyarul aib, option of defect. Khiyarul ru'ya, option of inspection. And khiyarul was option of description. So we are not going to discuss everything on all types of option. As we mentioned earlier, we discussed today 4, right? Option of majlis and khiyarul shart and khiyarul ru'ya and khiyarul aib. Okay, what is the process to establish an option? How an option can be established? Or when you can utilize the option, or when you can exercise this right? Does it come automatically to you by default, or you have to put in the contract as a condition, right? So yes, there are certain types of option that will come to you automatically by default. You can exercise this option. For example, option of inspection, khiyar ru'ya. This is established by rule of Sharia. Rule of Sharia means automatically by law, right? When we say rule of Sharia is automatically by law. Let's say you buy something, but you didn't see it before, right? And you are not given any description. So in that case, automatically you can apply khiyar ru'ya. If you don't want to continue, you can cancel the contract. Same goes option of defect. If you found any problem in the subject matter, so you can straight away cancel the contract. That comes automatically. That not necessary. It should be mentioned in the contract, right? However, if there is mention that any default or any fault you cannot refund, you cannot return. If you agree, then you cannot return. The agreement always should be given priority on the custom and on the rules. If the rules say you can refund, you can get refund, but both of you agree that there will be no refund. So your agreement will come first, right? Even though it goes against the norms. I hope you understand. So option can be established by rule of Sharia automatically. For example, khiyarul ru'ya or khiyarul aib. Second point, option can come by mutual agreement. This is not automatically. This is you have to put in the agreement and you have to agree. All of you should be agree. For example, option of stipulation, khiyarul shart. Khiyarul shart means you have to say, okay, I am buying this one, but I have 3 days option. within 3 days, I can cancel. So this is, the seller should be agree on this. Right? And also option of determination to fix up which one you go through. So the option can be established two ways, automatically by law and by mutual agreement. All right. So first one, we discuss Khiyarul Majlis, option of contracting session. What is Khiyarul Majlis? It is conferred on each of the parties to a contract, allowing them to rescind, means to cancel it, or not to proceed with concluding the contract before they leave the contract assembly. Very academic language, right? Very bookish word. So simple way. Previously we discussed about Majlisul Aqad, right? Why the buyer and seller, they come to Majlisul Aqad to bargain. So they have all types of freedom to buy or to sell or not to sell, as long as they are in the Majlis. Once the Majlis is over, they go away or they close the Majlis and they leave, then the contract becomes final if they already concluded it. So this option related to the Majlis only. This option will be available as long as Majlis exists. If Majlis already finished, this option also will be finished. Right? Let's say we agree that we come together for 1 hour. 1 hour we will be in the session, virtually or physically, no problem. Once we logged in, we are in the Majlis. So once we logged out, the Majlis finished. So once the Majlis is finished, we don't have any option. Whatever we agree in the Majlis, that becomes final. This is called Khiyarul Majlis. Khiyarul Majlis means you have the option to buy or not to buy, as long as you are in the contracting session, as long as you are in the Majlis. Once the Majlis is over, the decision becomes final. All right. This is the Prophet mentioned in one hadith. The two parties, means the buyer and seller, they have option as long as they have not parted, means as long as they do not leave the Majlis, as long as they are not separated. And one of them may give the other the option for a longer period. Right? So as long as you are in the Majlis, you can apply. You can think whatever you want to think, you can deliberate, no problem. But once you leave the Majlis, your decision becomes final, whether to do or not to do. All right. However, a scholar have some opinion, some disagreement on this. Majority scholar says, okay, Khiyarul Majlis is valid, right? As long as the contracting parties has not separated physically or through mutual agreement. They resort to the previous narration to defend their opinion, because the hadith mentioned the Prophet ﷺ that you have the option as long as you are not separated, you are not becoming separated. Okay. However, a minority group like Hanafi school and some Malikis, they said there is no Khiyarul Majlis. Right? Means what? As long as you have done ijab and qabul, the contract becomes final, even though the Majlis continues. Right? Let's say the Majlis is for 1 hour, but within first 20 minutes, already ijab and qabul done. So the contract becomes final. After this, no option, even though you are still in the Majlis. Right? So what is their logic? Their logic is, the Prophet said you have option as long as you are not separated. That one, the separation by speech, by discussion, not the physical separation, not the separation from Majlis. So as long as you finish your discussion, so the decision becomes final. Even though after this you continue in the majlis, you are chatting, you are discussing many things, but as long as ijab and qabul is done, the contract becomes final. So these Hanafi and Maliki scholar, they want to say this khiyar is basically khiyarul qabul, not khiyarul majlis. Khiyarul qabul means option to accept the offer, right? Once I made you the offer, so you have the option to accept my offer or not. Once you accept my offer, the contract is final, right? But Shafi and Hanbali school say no, no, no. Even though you finish the discussion, as long as you are still in the majlis, you can rethink your decision. So that's the difference between these two opinions. What is which one we prefer is up to you. You can choose anyone. It's up to the situation. We have to put it in a particular context, right? Then we can make a fatwa or we can make a decision. But overall, Khiyarul Majlis is valid. We prefer the Shafi and Hanbali opinion. But however, it should be understood based on the customary practice. What is the nature of Khiyarul Majlis, and what is the feature, right? How we can define a Majlis and how long it should be, right? So the application can refer to the non customary practice, but it is valid. Khiyarul Majlis is valid. Okay. Any question on Khiyarul Majlis? Then we go the second one. You understand Khiyarul Majlis? Clear? Faham? Okay. Okay, good. Okay, second one, Khiyarul Shart. Khiyarul Shart means option of condition. Means you have to put in the contract that condition. So what is Khiyarul Shart? Is basically having option to continue or not to continue with the contract within the specific period, and that is maximum 3 days. So this is the long academic definition, but I always advise my student not to memorize the definition and not to memorize the book, to understand and to write in your own language. Once you understand, you can simplify, right? So what is khiyarul shart? Having the option to go to continue with the contract or to cancel it. Simple. So I have freedom to go with the contract or not to go within the 3 days. But to enjoy this option, I have to mention it in the contract. This is called khiyarul shart. I have to make it short. I have to make it conditional in the contract. I have to put a clause in the documentation. Okay. So which one party or both of them stipulate for themselves or for someone else the right to revoke the contract within a determined period. So from the definition, we have learned that khiyarul shart can be for the seller, can be for the buyer, or can be for the third party. The seller will say, okay, I will sell my house, but I have to think 3 days. The buyer will say, okay, I will buy your house, but I will confirm after 3 days. What about third party? Any of the buyer and seller, they can say, okay, I will sell the house, but I have to consult with my lawyer. I have to talk to my father. to my guardian, right? So this is called third party. So Khiyarushat can be stipulated for the third party as well. For example, the purchaser says, I purchased these things from you, but I have the right to return it within 3 days. Okay, this is called Khiyarushat. The legality, there is a Sahabi called Hibban ibn Munzir. Hibban bin Munzir, he always become cheated. People cheat with him because he doesn't know much about the buying and selling. Sometimes he can't see properly. So he asked the Prophet regarding this. The Prophet says, when you buy or sell, you mention no cheating and I reserve option for 3 days. Because you are not expert in buying and selling, so don't finalize it immediately. Take time, right? So the Prophet ﷺ advised him to take time for 3 days. So this is called khiyarushat, right? Imam Shafi and Imam Ahmad say this condition should be stipulated at the period of the contract. It is allowed to stipulate until the end of contracting session. Yes, if you say khiyarul majlis is okay, then you can put this option in the until the end of the contracting session. So as long as you are in the same session, you can say, okay, I will buy, I will sell, but I have to think for 3 days. Within 3 days, I can revise, and if I want, I can refund. I can return the subject matter. Okay. Contract in which khiyarushat is permitted. Khiyarushat is permitted contract that accept revocation. That's something revocable, you can cancel. For example, the sale contract, the lease contract, the partnership contract, that is khiyarushat is applicable. Khiyarat is not applicable for the divorce and manumission. Manumission means releasing the slave. Khiyarat also is not applicable to salam and sarf. Sarf means the exchange contract, money exchange contract. Salam means forward delivery sale, right? So Khiyarat is not applicable. Also, Khiyarat is not applicable for the wakala contract, agency contract, because these are not revocable. Once wakala is done, it becomes final, right? For whom? As I mentioned already, for buyer and seller, either of the parties, or for third party, like guardian, like wakil. Whatever the duration, um, Imam Hanbali school, Imam Abu Yusuf and Muhammad said, no restriction for maximum period. As long as you need much more time to think and to deliberate more, then you can take it. No restriction. Imam Abu Hanifa Shafi says 3 days because it is mentioned in the hadith, so it should be within 3 days. Imam Malik says depends on case to case basis. Sometimes some asset or something need much more time, right? For example, 1 month for house, 1 days for a piece of cloth, right? So we have found many opinion regarding the duration, but how we can conclude? To me, 3 days is the basic, right? 3 days is the basic, but for certain reason, if the buyer and seller needs much more time, let's say I'm going to take over a big industry. So a big factory, I cannot inspect it, I cannot see it, I cannot check everything within 3 days, right? So in that case, maybe I can ask more, right? I can say, okay, we have to give me 2 weeks, 3 weeks to check everything, then I confirm whether I will take over your factory or not. Okay, as Maliki school said, it depends on case to case basis. But for the general kind of thing, normal buying and selling, the 3 days is good enough, right? 3 days is good enough. Because what is the purpose? The purpose is to be able to come up with a good decision, right? An informed decision. So if you don't want to give enough time, then the purpose will not be served. The objective will not be fulfilled. If you say for a big factory or 3, 4 factory, I'm going to take over, and you don't want to give more than 3 days, then my purpose will not be served. I cannot finish to check everything within 3 days. Okay, so it depends on case to case basis. The effect. What is the effect of the contract with Khiyarat? The effect do not come into operation. The contract is suspended. Uh, any contract with Khiyarat, it means the contract is not final yet. It is the pending. Another opinion, the contract is final but not binding. Right, not binding. What does it mean? There are two category of the contract. Some contract, when you conclude, it becomes final, binding. You cannot revoke. Some contract, once it is concluded, you can cancel it. Not binding. It is revocable. For example, let's say wakala, I appoint you my wakil to do something, but immediately after this, I can cancel it. Right? But for buying and selling, if you buy something without option, then it becomes final. You cannot cancel it. Okay. So basically, that's the point. Because with option, the contract is not final yet. So we can say the contract is the pending mode. Yes, no, pending. So we can click pending. Right. How an option can be exercised? How you can apply the option? You can apply expressly or impliedly. Right, indirectly. No court order needed. This is very simple. Just put it in the documentation or put it in your discussion. To apply this option, you don't need to get the order from the court. Right? It's subject to mutual agreement. Khiyarat is subject to mutual agreement. Termination, when it is finished, death of one whose favor the option was operating. Let's say Khiyarat is for the seller. So if the seller dies, the contract becomes final. If the buyer dies, the contract becomes final. It doesn't pass to the inheritors, to the children. Termination of the period. If 3 days is finished, the contract becomes final if you don't answer. Right. Destruction of subject matter. If subject matter already destroyed in your hand as a buyer, the contract becomes concluded. So Khiyarat will be terminated by death of the party, by termination of the period, and due to destruction of the subject matter. Okay, done. Khiyarat. Any question? Khiyarat has many application in Islamic finance and in our real life. For example, when we talk about the Murabaha financing in Islamic banks, the bank or customer can apply Khiyarat. The option contract in the what I call derivatives market, Islamic option can be structured based on Khiyarat, right? Also, the treasury product, right? Like a derivatives and so on can be also used by Khiyarat, can be structured by Khiyarat. Okay. Okay. Any question so far on Khiyarat? No question? Paham? Okay, Alhamdulillah. Okay, next, khiyar ru'ya, option of inspection. Something if you buy without seeing, without earlier observation, without any description, so you can apply this option, right? This option, as we discussed before, is comes automatically by law. No need to discuss. It's not subject to mutual agreement. All right. So what is khiyar ru'ya? Again, a long definition. Right accorded to a person buying anything not yet present at the moment to confirm or cancel the said contract after inspecting the object. Means if you buy something without seeing the picture, the description, the details, anything, just blindly you agree, right? Then after receiving or after seeing the item, you got surprised that you thought something, now you see different thing, right? So in that case, you simply can cancel the contract if you don't want. Okay. So what is khiyar ru'ya? The option due to not having any earlier inspection because you didn't see it before. That's why you can apply it. But if you saw already the subject matter before, so after this, no khiyar ru'ya. After this, only khiyarul aib, right? If you found any problem, any the risk any old problem, any traditional problem, traditional fault, then you can apply khiyarul aib. Okay. Opinion regarding this, Imam Shafi says totally invalid. Contract in which the subject matter has not been examined is not valid. Imam Shafi says you cannot buy something without seeing. You have to see it, right? Other schools said valid in some cases when examination at the time of contract becomes difficult. Hanafi school say valid, sale by description, but you can apply khiyar ru'ya of the object is allowed. So some school are very strict. They said even you cannot buy anything without you see it. But it's normal, or not always we are able to see. We have to see the picture. We have to see the design. We have to be satisfied with the design. So that's why Hanafi school says sale by description is valid, but still you can apply khiyar ru'ya. Right? Arguments: the contract is enforceable but not binding. The hadith do not sell what you do not possess apply to one who does not want the good, not does not have capacity to deliver. Based on narration that Talha was given khiyar ru'ya against Usman. So these are some evidence that khiyar ru'ya is applicable. Right? The condition of khiyar ru'ya, the buyer must not have seen the goods before, as I mentioned. The property must be in property which possesses its own individuality, like the house, land, horse, etc. Means every single item is particular. Right? Let's say a house. If I say just simply the house is 1,000 square feet, two-story, a second floor, blah blah blah, but it's still not enough, right? Every house is different. It has own individuality. But let's say if I tell you a car, the model is this, the brand is this, so it is very much standard, right? So if for the car, the description is okay. But for the house, for the animal, for a piece of land, the description is not always okay. You have to see it, right? When you see a house, is the location, is the design, is the neighbors, right? And many things in concern. So not always by showing the picture, by showing the details is enough for something, for house, for land like this. That's why you have to see it, right? But for standard items, perhaps the description is okay. the item that we buy Lazada and shopping, some standard item is fine, not much different item to item, right? That's why sale by description is okay. But for a piece of land, for house, for something else, the description, simple description is not okay, right? That's why you can apply this option if you buy without seeing. Effect, the contract is not binding, of course. This is answer. This is the answer for all types of khiyar. Any contract along with the option becomes non-binding. Non-binding means you can cancel it. In Arabic, called غير lazim. Remember we discussed iltizam, obligation. So from iltizam, the adjective is lazim, means obliged, binding. And when we say غير lazim, غير means no, so not binding, right? So the contract becomes غير lazim. Contract is concluded but not binding. You can cancel it. However, it is irrevocable for the seller. Remember, khiyarul shart can be for the seller, can be for the buyer, can be for the third party. But khiyarul ru'ya is only for the buyer because the seller doesn't have any objection. He wants to sell. So the contract from his side is final, is irrevocable, means the seller tabole cancel, cannot cancel, right? That's why it is irrevocable for the seller. But for the buyer, it is revocable, means the buyer can cancel it. Okay, I hope you understand. Factors terminating the option: when the khiyar ru'ya becomes over, becomes terminated, expired. It ends with the inspection of the object. If you see the object already, done. Destruction of the subject matter. If subject matter become destroyed, finish. Death of the buyer. If the buyer dies, then the contract is final. But if the seller dies, then the buyer still have the option. Right. Okay, done. Okay, this is about khiyar ru'ya. Any question you can ask in the chat box. Okay, the last one, khiyarul aib, option of defect. So why it is option? If you discover that the object acquired has in it some defect diminishing its value. Let's say you buy an item. It happens always with us, right? You buy an item, and when you come in the house, oh, you saw in the item that big problem, right? Some defect. The defect is not happened by you; it's already there, right? Then you can simply change the item, or you simply cancel the contract. But the defect should be something that diminishing the value, or something does not fulfill your objective. Right. Let's say you buy a rice cooker. It happens to me. And that's why I'm giving you the example of rice cooker. You buy from the market. Once you come into the house, you saw, oh, there is a problem. You cannot cook it. The cover does not match properly. Right. So it will not be warm enough, and you cannot cook it. So your function will not be served. Right. So even though sometimes the problem is little, but if in terms of the function it is huge, then you can simply cancel. You can simply the change, apply for the change, or you cancel the contract. So this is the khiyar due to the problem. The Prophet mentioned, he who defraud another is not from amongst us. The Prophet advised always not to cheat any in the contract, or not to do fraud, right? So who cheat, he does not belong to Muslim, I mean he cannot be a Muslim. It is not permitted for seller to sell things which are defective unless he points it out to him. You know already there is a problem, so it's good for you not to sell. unless you clarify, you already inform, unless you inform the buyer that hold on, this is a problem, there is a problem. If you still want to buy it, it's up to you. Right. Very good person, right? But very rare nowadays. People always try to hide the problem if there is any problem. But they can cheat the customer, but they cannot cheat Allah subhanahu wa ta'ala, right? The observe the inspection, the camera is there. That's why the Prophet advised always not to do any fraud, any cheating, any kind of misrepresentation, manipulation in the contract. All are haram. This kind of things is haram. Right? Condition for exercising fair life. It causes decreases in the subject matter. The defect was existed before the contract. The buyer should have no knowledge. The defect should continue after delivering till the time of exercise of the option. No agreement of non-guarantee. So if the problem causes decrease in the subject matter, reduces the value or reduces the benefit, then you can apply this option. The defect was there. It's not your fault. It is already there before, then you can apply. You don't know it. But if you know already, but still you agree to buy, then no option after this. Because I already informed you there is a problem. But still you want to buy, so it's up to you. And the defect should continue after delivery till the time of exercising the option. If the problem already over, then you cannot apply this option. And no agreement of non-guarantee. This is the point. If you agree already with the seller that after this, no return, and I don't want to give you any guarantee, means once you buy it, you cannot return it. So in that case, you cannot apply Khiyarul any option. Always agreement will get priority over the customary practice, right? Over the norms. So if you agree that no guarantee, then you cannot apply this option. What is the effect? The contract is revocable. You can cancel it. Maliki jury said if the defect is minor, the buyer may confirm the sale while being returned part of the price. Very small problem, still you can use it. So in that case, you cannot cancel the contract. You will be given the compensation. Hambali jury say the buyer may confirm the sale if he compensated regardless of major or minor. Hambali says you can still continue with the contract, but you can apply the compensation. All right. So it's up to you. If you want to continue and the seller wants to give you compensation, then okay. If the seller say no, I don't want to give you any compensation, you can return and you can change the item. Put this one and take another one. So in that case, you have to do it. Okay. So for Khiyarul Aib, there is many options. Either you cancel the contract or you can apply for the compensation is subject to the agreement between the buyer and seller. When the Khiyarul Aib becomes expired, acceptance of object with defect. If you say, okay, no problem, I accept it, I don't mind. So, okay, no option. Destruction the item in your hand as a buyer. The item is already destroyed in your hand because of your fault. So you cannot apply this option. Death of the buyer does not terminate Khiyarul Aib. This is I put red color because it's something different, right? In Khiyarul Ru'ya, death of the buyer terminate. But in Khiyarul Aib, death of the buyer does not terminate. Means if the buyer dies, the buyer's inheritors, son or daughter can apply and can return the item, right? As long as there is evidence, as long as they keep the receipt or any document. Okay. There are other types of option I already mentioned. Khiyarul Ta'yin, Khiyarul Rukban, meeting the caravan, Khiyarul Naqd, price payment option, but these are a small option. The major one, the 4 option that we have discussed: Khiyarul Majlis, Khiyarul Shart, Khiyarul Ru'ya, and Khiyarul Aib. Okay, so I think that's all for today. Is the Islamic concept of option is similar to the conventional financial option? You can, I think there is a YouTube video, you can watch it. You can make this one a short assignment by watching this video or by reading other materials. What is the difference actually between Islamic option and conventional option? Is it the same or is it something different? Okay. So that's all. We discussed Khiyarul Majlis, Khiyarul Shart, Khiyarul Aib, and Khiyarul Ru'ya. Okay. So any question you can ask, and there are some review question you can go through. Okay. Okay. Thank you very much. Now your turn. Any discussion or any question? So next class, next week, for the short assignment, of course, you submit on the clip, but here some of you should discuss and should present what's your findings. What is the difference actually between Islamic option and conventional option, the derivatives product option that have been used or have been exercised in the derivatives market. Okay. Okay. Any soalan? This is the attendance link. By group, by group. Okay, I think no question from your side. So thank you very much. So we are going to finish the session here today, inshallah. Later on, after going through the slides and other discussion and recording, if you have any further question, you can ask in the WhatsApp group also, or maybe next class also you can ask, no problem. Okay, thank you very much. Wabillahi taufiq wal hidayah. Wassalamu alaikum warahmatullahi wabarakatuh. Subhanaka Allahumma astaghfiruka ashhadu an la ilaha illa anta wa atubu ilaik. أعوذ بالله من الشيطان الرجيم والعصر إن الإنسان لفي خسر إلا الذين آمنوا وعملوا الصالحات وتواصوا بالحق وتواصوا بالصبر. السلام عليكم ورحمة الله وبركاته.
Waalaikumsalam. Thank you, Doctor.
Okay, you're
Salam. Thank
welcome.
you, Doctor.